So tonight we explore two issues. The first one has to do with the embattled Chief Justice Gertrude Arabai-Saba Tokonu, who filed an injunction on May 21 seeking to restrain a 6-member committee established by the President from proceeding with his inquiry into petitions submitted against her. She also requested the disqualification of 2 committee members, Justices Gabriel Puamang and Samuel Adibu Asiedu, citing concerns about conflict of interest and impartiality. However, in a unanimous decision, that's a very interesting word, unanimous decision, the Supreme Court dismissed the application and says its ruling would be fully delivered on the 12th of June. Now, reacting to this, the former Attorney General and Legal Counsel, now to the CJ, has argued that the legal threshold for granting the injunction against the proceedings seeking her removal had been met in his view. Appearing before the Supreme Court on Wednesday, 28th May, which is today, the former Attorney General contended that no prima facie determination was made regarding the petition that initiated the CJ's removal process. He pointed out the President's letter to the CJ referenced a prima facie case only briefly in its 3rd and 4th paragraphs without offering a detailed evaluation. We'll hear from Godfrey Dami shortly. According to him, this falls short of the constitutional requirement for a quasi-judicial process, including a prima facie assessment as outlined in Article 146 of the Constitution. He also said a few other things. So we're going to discuss this first, and then we'll move to the ChannelOne case. In studio is Member of Parliament for Bongo, Charles Bawadua, who is a lawyer himself. Honorable, welcome to the show. Good evening.
Thank you. Good evening.
So quite interesting to hear the former Attorney General complain about the matter. We heard him talking about, he said the decision was strange. It seems as if people in the NDC are quite determined to push through this attempt to remove the former, the CJ who's been suspended. And therefore, I'm sure you will say that what the Supreme Court decided today was not strange and you were happy and expecting it, correct?
Thank you, madam. Let me first of all say good evening to my constituents and your viewers as well.
All right.
Well, I think that we should look at these issues not on the basis of politics, not because one belongs to a particular party, NDC or MPP or any other party. I think we have to look at it on the basis of law. I mean, this, for me, this is a purely legal matter, and specifically a constitutional issue. Our constitution is being called upon to be enforced, as has been provided in Article 146. That's how we should look at it. And at the end of the day, the outcome will be dependent on the facts and the legal processes that have been followed. It is not about one's political coloring. So it's not a question of me being happy or any NDC member being happy. I think it's a question of all Ghanaians, seeing and then observing that the legal processes have been duly followed. It can't be one of politics at all.
Well, the former Attorney General says he's surprised that the court could not see the glaring merit in the injunction application from the CJ. What do you say?
Well, I am surprised that he was surprised because, look, this is a constitutional process that was ongoing. Before you can injunct a constitutional process, you must have very good reasons. If you read, I mean, the affidavit that was attached to the application, and I have had the opportunity to also look at aspects of it, there is nothing substantial that will warrant the grant of an injunction. An injunction is a very serious order of the court to stop a certain action that is taking place. You must have very good grounds. They failed to adduce grounds or depose to grounds in their affidavit that met the standards for a grant of an injunction. And so, if the court, refused it, I'm not surprised that I'm surprised.
But he contends that no proper prima facie determination was made regarding the petitions that initiated the removal process. He says they were just a perfunctory mention in 2 paragraphs, and so they don't even know the basis upon which that determination was made for even her suspension. No,
but that is his view. Let me also say that the processes of removing the Chief Justice requires it to be secretive. It requires that it to be held in a camera. So you do not expect that there will be an elaborate enumeration of the facts, allegations, and all that has been alleged against the Chief Justice, or the basis upon which the President has made a prima facie case against the Chief Justice to be brought out. You understand? So he can't expect that in totality. Because the process expects that, one, the Chief Justice be protected, and then two, of course, the judicial system also be protected. And so it's a constitutional process. I do not think that anything was wrong at all.
Well, earlier on, we understand the Deputy Attorney General had also tried to file a particular process to exclude some of the justices from the committee from this particular matter. The court did not agree with them. Any surprises there?
No, you see, this process, what the court is looking at in totality is to ensure that the constitutional provision as elaborated in 146 are complied with. Anything that will unnecessarily thwart that effort, the court would not agree. So you will see that it is not a political court. It gives a decision based on the facts and the law. And that is why it will make decisions against the Attorney General and also make decisions against the applicants. And that is why when a decision is not made in your favor, you ought not to see it as being political. It is just the legal process which is ongoing.
So as far as you are concerned, everything that's happening is very legal, and therefore there's no cause for complaint.
I see no flaw anywhere. It's a very legal process, a constitutional process, a very clear one. And you see, Article 146, in my view, is one of the clearest provisions in that constitution. And it's so clear that it doesn't even admit of any interpretation. So there should be no doubt as to what Article 146 means. And so when it's being called upon, it's being enforced, and the facts support it. Unfortunately, the only problem with that, and I think it is for good, is that you are not able to see the full facts. So you have this perception that what is ongoing, and we don't have the full fact, but that is what the Constitution says, that let this be held in camera.
Okay. You know, when this matter came, a lot of people, or some people had said that we needed a CI to elaborate on the modalities for a removal of such a person. And in fact, yesterday, your leader, Majority Leader Mahama Yariga, now says government is going to introduce new rules on removal of Superior Court justices. So essentially, he recognizes that there needs to be some clearer rules. Aren't we putting the cart before the horse? Shouldn't this have been done before even this matter be heard?
No. But you see, Article 146, in my view, is very clear. You may want to add more, as some have suggested. But there is nothing ambiguous about 146. The desire by some people to have regulations or a CI that will elaborate some steps does not mean that the substantive provision, which is 146, should not be enforced. I mean, we are in this country, many laws have been enforced before the subsidiary legislations have come.
But my question is, why is Ayariga now saying that government will introduce legal reforms, including the introduction of detailed procedures for the removal of justices of the Supreme Court and other Superior Courts? So clearly, there's a gap there.
No, you see, what I'm saying is this.
In fact, he said these are intended to address gaps in the current constitutional and legal framework that have led to confusion and legal disputes in recent high-profile cases. He stressed that the proposed rules would bring much-needed clarity to the process and eliminate the ambiguities that have plagued the recent removal attempts. It's very clear that the leader of the majority obviously admits that there are challenges with the understanding or the operationalization of 146.
No. You see, the problems that I see is because the nitty-gritties of what steps to follow is not what has been provided in Article 146. But the meaning and extent of Article 146 is clear. But what steps should come after which the others should follow have not been provided for. And this is not new. You do not expect everything to be provided in the Constitution for every article. Otherwise, we'll have a very bulky document. So you will see that in some provisions in the Constitution, it talks of the minister or the government making regulations or a constitutional instrument to give more clarity to some provisions.
Yes.
You understand?
Yeah, but that's what people were asking for. Yeah, people were asking for, you see, nobody's saying the Constitution should be amended. They are saying that the current existing framework and Article 146 lacks sufficient procedural detail and leaves room for political interference. And I'm saying that Ayariga in Parliament, yesterday you were there, this is the first day of Parliament in this session.
Yes.
He goes ahead to say that there are vulnerabilities, and therefore the need for clarity.
Yes.
And I'm saying that if that is the case, why, if this is, or is he now realizing it because of this case?
No. You see, Bernard, the point is this, that the lack of a CI giving detailed steps does not make the Article 146 inapplicable.
Okay.
It doesn't make it.
But it makes it subject to abuse.
It is clearer when the steps are spelled out. But the meaning and extent of it, as it exists now, is also clear. So you do not say that I will not enforce or apply Article 146 because a CI has not been passed.
But
Article 146 is not subject to the provision of a CI.
The CJ's problem with all of this is the way it's being operationalized. And Mr. Ayariga is saying that we need clarity. He says we need sufficient procedural detail.
Yes.
The woman is concerned about the procedure. She's not saying that Article 146 does not empower the president to remove it. She's saying that the procedure you've adopted is unfair. And I'm saying that from what your leader has said in Parliament, clearly he agrees.
No, you see, what the leader is saying is that, yes, it is good we have detailed steps as to how this could be enforced. It doesn't take away the fact that this article is still in effect and should be enforced.
I see.
You see, the extent of that article, how it should be issued, the president should go about it, the committee and how it is supposed to be set up, how a warrant can be issued by the president, and how same can be revoked, are all provided in 146. And so there is no doubt whatsoever the meaning of 146. And it is good to have, details as to what steps should come after the other. But that is just for purposes of clarity.
Okay.
But it has nothing to do with the effect, extent, and meaning of 146.
Fair enough. Point of view tonight is very legal. Tonight we're dealing with many issues. The CJ's matter, the 6-member committee looking into, or essentially trying her in camera to essentially prove whether she has done anything wrong to merit her removal. We are digging into that. My guest in studio is MP for Bongo, Charles Bawa Dua. Let me go to one of our lawyers. I mean, I call him a public policy lawyer for Ghana, Martin Kpebu. He's been talking on a number of issues. He's following all these matters very, very closely. Just pick his quick thoughts on what's happened so far with the CJ matter before we move to the next issue. Mr. Kpebu, thanks for joining us. Good evening.
Good evening, man.
So it's good to have you, and I've kept you awake long for today. I was wondering whether the call by Mahama Ayariga yesterday in Parliament or the announcement rather, that government is preparing to introduce a comprehensive set of rules to govern the process for removing justices of the Superior Courts, including the CJ, whether that is not an admission of a certain lack of clarity in the procedure surrounding Article 146. This is how a layman like me sees it. What do you say as a lawyer?
Oh, definitely. It's an admission that Article 146 needs a lot of improvement, for lack of a better word. It needs a lot of fleshing up. It needs a lot of improvement. It needs a lot of efficiency. Yes, efficiency pumped into it, and effectiveness. That one, nobody can run away from it. And Bernard, it didn't start today. The first call came about 20 years ago, in 2005 or 2006, the Frankie J. Chum case. That was the petition presented for the removal of Chief Justice Akwa. So when the Supreme Court went into the case, in their various opinions, the justices asked for rules, detailed rules, comprehensive rules to guide the process. They needed to do proper stewardship, right, to go through the process. And we had been playing football with it, or if you like, some would say kicking the can down the road. So we've kicked the can down the road for about 20 years now. So, and that has straddled many governments. And NPP, then NDC came 8 years, then NPP came another 8, and then NDC is back. So it's affected the two major political parties, and nobody can run away from it. Except that we cannot halt. I hope I'm not running ahead of myself.
No, you are fine. I wanted to ask that you've preempted my question. I'm saying that if the majority leader has now realized that we need procedural clarity, does that not mean that we are probably experimenting with this CJ removal in an atmosphere of uncertainty?
Yeah. Bernard, this one, the words that you have something to say. Your question certainly has something
No,
to
no, no. Let me phrase
say.
it. Let me phrase it again. You see, we have admitted that 146, in terms of the substance, is not a problem, but the procedure as to how it should be gone about needs more fleshing out. But I'm saying that this is we are taking a CJ through a process now, which in a sense we are admitting that that process needs more detail. So are we not putting the cart before the horse?
We are not, but that does not. I like your first question. I'll just say that it's too strong. But your first question was more, I mean, and it's better. You know, you have been in this business for decades. So sometimes you see, I laugh because it hit me, right? So I didn't think that it wasn't relevant. That's why I started by saying that you have something to say, except that it was too strong. Okay? Too strong, yes. So the truth of the matter is that it's not only 146 that needs more efficiency pumped into it. But now there are a lot of other laws that we need. Look, let me mention a common one, and I'm looking for people to partner me on it so that we can make Ghana a better society. Look at jail. I mean, people, remanding people. Look, Bernard, you know, at least from where you may own at least 2 houses, because I know you won Journalist of the Year, and then you got a house, and I know that
no. I didn't get a house for Journalist of the Year. I got a mattress sofa from Ash Foam. I didn't get a house.
Okay, but
so
okay,
I don't own 2 houses. I just own 1 house. Please.
Okay, but I don't, you are talking about mortgages extra.
I own 1
so,
house.
Bernard, you own a house. Now, does it make sense that tomorrow, God forbid, touch wood, for some reason you need to be detained there? Why should you be in cells, Iyoko cells, police cells, when a house arrest will do? Okay? So what I'm saying is that currently, our laws don't make provision for house arrest massively. Once in a while, when a big man in society is involved, then you kind of see some form of house arrest. I remember the last one we heard was this man, Timbila. But now, a lot of us, people own 5, 10 houses. And then you say, no, he should go and lie in some cells. So what I mean is that currently, our laws on bail, they are not the best. They are archaic, but we are using them. So we can't say that because they are archaic and some people are in custody, we should free everybody, go and improve the law before we come back. So that's just the example I wanted to give. So 146 has its challenges, but we can't say because CJ Tokonu is going through it, we should stop, go and amend the law before we come back. Then all the persons who are in custody now, Edubuahi, you see even the Mayfair properties and the other things, more than 30 houses, all right? Yes, he too could have said no. He doesn't want to be in Iyoko cells. He wants to have house arrest. He didn't have that option. He was in Iyoko cells. So the same way Chief Justice Tokonu's own, we are yet to improve the law. So for now, what we have is what we use.
All right, fair enough. Let me just get clarity on what happened in court today, because initially some of us were confused. Initially, we were told that the AG had made a certain application, I think, to disjoin 2 of the justices on the panel from the application that the former Attorney General had filed for the CJ. And the court refused that. But then the court also refused the application substantive that Mr. Dame filed for the CJ. I just needed to clarify that, because initially we were confused. Like, how can you say no to the AG and at the same time say no to the CJ? Because they are on opposite sides. So I need you to clarify that if you've been following, please.
Okay. So the former AG, Dame, says that, let's start with the current AG, Deputy AG.
Yeah.
He says Scott Waman and all the members of the, what do you call it? The committee.
The committee, yes.
Yes. They should be struck out because they were performing official duties when they were sued. So SREMSI's argument is that they were performing official duties. So in that case, the suit against the Attorney General is sufficient to cover them. Then the Supreme Court said, no, once the reliefs are touching them personally, you can't say they should be removed from the case and the Attorney General should answer for them.
Okay.
No. So that's why. So AG says, Deputy AG says, people are doing official duty. If they did anything wrong, the Attorney General will answer. Supreme Court says no. They've been accused personally. So let them answer, even though personally, but through the AG. Even though personally, through the AG. Then Dami came with another argument that the AG should not even act for them. Dami was saying that, I've accused these people. The Tokoni is accusing these people personally. So AG should not act for them. Then the bench said, but it's the state that asked them to perform some public duties and they got sued. So it's only reasonable that the state should bear their legal fees by representing them.
Okay. So that's the first one that current Deputy AG filed. Then we understand that on May 21, CJ filed an injunction seeking to restrain the committee from proceeding with his inquiry whilst a substantive matter was on the cards. And I believe the court said no by unanimous decision. Correct?
Yes, correct. Okay, we should explain that. Yes.
Briefly, yes.
So you see, the hearings going on. What's happening is that CJ Tokono has sued that, among others, will summarize. But I know she asked for 16 reliefs. So let me just use 2 or 3 to just demonstrate 16 reliefs. She's saying that, listen, this trial is going on, but I don't even know how the president and the Council of State arrived at the prima facie, that's to say the decision that the trial should go on. The 5-member committee should be constituted and to go into the matter in details. She's saying, I've not seen it. And that one, I think there's some merit in that particular point. Yes. She's saying that, you see, ordinarily, if you go to a court, somebody has been accused of an offense, if at the end of the state's presentation of its evidence, the judge says that the accused should come and answer, the judge will give a reasoned opinion, reasons, saying that, okay, let's say the state brought 10 witnesses. Bernard Avlet said this. Bawadua said this. Jude Duncan said this. Hansen said that. And at the end of the day, I think that you accused person, Mr. XY, you should come and answer. So the judge will explain. So the example Tokonu, so given that example, Tokonu is saying that she has not seen what the petitioners have said, which has found favor with the Council of State and the President, and for which reason they say she should come and answer. So she wants to see that document, what went into it. That one, I think there's some merit in it. But put that aside. So what she's saying is that now that I've not seen the document, if I continue the trial, then by the time the Supreme Court comes to a decision, if they come and say, I should see that document, and by then you finish the investigations, and then I've lost, then it means that the Supreme Court decision will be useless. So you even call it, in Ghanaian English, we say the Supreme Court decision is a foolish case because it would not have helped me. So because I'm likely to win the Supreme Court case, and not just likely to win, because I'm going to be irreparably harmed, the harm I'll suffer cannot be compensated in money, she wants the committee to stop the work. That's what the meaning of the injunction says, stop the work and wait for the Supreme Court to go into the case to see whether, for example, I'm entitled to see the basis on which President Mahama and the Council, with President Mahama, but advised by the Council of State, said I should come and answer the charges. Is that clear?
That's very, very clear. But it's the same Supreme Court which then sat on the matter today and said, we don't agree with you. So that's quite interesting, right? So maybe one day, in a different world, we could have a separate court. Because sometimes I, as a non-lawyer, I ask myself, how can a Supreme Court sit on a matter in which the Supreme Court's name has been brought? Do you understand? Because somebody says, the Supreme Court has not finished its work, therefore the committee should pause. this same Supreme Court sitting on that matter and says, no, we've not finished our work, but we can still let the committee do their work while we finish our main work. Maybe in a different constitution, we could say, let there be a court of arbitration or something, some other court to look, because it seems a bit weird for a court to be sitting on a matter in which somehow his name has been mentioned, but that's for a different argument, I'm sure.
Yes. Yes, there's something to be said. So that particular one there, it will be interesting because that one, going by even layman argument, it makes sense because she's simply saying on what, out of the petition, which of the grounds, which one found favor? Are you saying everything found favor, or maybe 60% of it found favor, or 99.99? So that one, I just hope that one going forward, we need to look at it again. And I don't see why that one is difficult to deal with. You know, when Professor Kweku as a petition for the removal of Justice Tokono, Ekufuado dismissed it. And you know, he brought his lengthy ruling. Okujeto said he wrote it. Okujeto said he wrote it for President Ekufuado, but it came out. So I'm wondering why this one, they don't want it to come out. She must see it. Maybe if they even say, look, we'll give it to you alone, the public shouldn't see, fine. But for her to go into the trial and has not seen the basis of the prima facie, that one, I think she has something to say. My only beef with her is her retaining Godfrey Dami to do that case. When Godfrey Dami has been caught on the tape, undermining the whole judicial system, suborning Japa, coaching Japa to go and lie to the court, coaching Japa to go and, you know, get a fake medical excuse duty, etc. You don't reward such bad behavior. Elsewhere, elsewhere, Godfrey Dami's license would have been revoked a long time ago. You see what America did to Rudy Giuliani. You see what they did to Rudy Giuliani? Hey, Charlie, those days when Giuliani was mayor of New York, hey, Charlie, Giuliani was the man. You see, when he breached the rules, they didn't say this was a great mayor of New York. So they revoked his license. In a serious country, Dami wouldn't have had a chance to practice law by this time. So Tokonu going to retain Dami there, it's not on.
Well, I'm sure you know that somebody has petitioned the General Electoral Council on this matter. So I believe we should allow that process to play out. Your views on Dami are well known, and I'm not here to try him. So I think that's a fair one. But I thank you for bringing light, as always, to this matter. We have been speaking to Martin Kwebu, who's a lawyer, following the matters that happened in court today. We'll take a short break. When we come back, we're delving into Bernard Intribuesiako, Chairman Wontumi, who had been invited by the police. Indeed, it's a three-piece issue. Initially, it was an attempt to arrest him in his home. That was botched. Then he was invited to the police. He went and released. On his way out, the Yoko grabs him, and he's not been able to come out of Yoko. We understand he's been granted a 50 million CD bail, which his lawyers are sweating to, I don't want to say what's the technical word? They basically are trying to meet the conditions. So we'll come and speak to some lawyers on that. My guest in studio is still here. The point of view is live. Stay with us.